Good morning. Welcome to the Subcommittee on Immigration and Border Security. It will come to order without objection. Chairs are authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing entitled New Orleans, How the Crescent City Became a Sanctuary City. I will recognize myself for an opening statement, and then my friend from California. I will introduce the panelists en banc, and then recognize you individually for your opening statements. As close as I'll ever come to being a judge, but there we have it. Time and time again, our nation has witnessed the tragic consequences of this administration's failure to enforce immigration law. Witnessing these tragedies is unsettling enough, but it pales in comparison to the grief and the anguish and the separation experienced by the families of those victimized. But today, we're not here merely to discuss the failure to enforce the law. It's even more disconcerting than that. We're here today because the Department of Justice, the entity that is supposed to be the chief enforcer of the law, is aiding and abetting local governments in the failure to enforce the law. Once again, the temptation to make a political point has transcended the obligation to take care that the law be faithfully executed. Under current policy, the New Orleans Police Department prevents its officers and employees from communicating with U.S. Immigration and Customs Enforcement regarding the immigration status of an arrestee. In May of 2010, New Orleans Mayor Mitchell Andrews sent a letter to then Attorney General Holder requesting DOJ, quote, transform the New Orleans Police Department, close quote. Based on the Department of Justice report, current Labor Secretary, then Civil Rights Division head, Thomas Perez, filed a lawsuit against the City of New Orleans and the Police Department, alleging various civil rights violations. On the basis of that lawsuit, the parties entered into a consent decree in 2012, which was approved by a federal court in 2013. This consent decree stated the New Orleans Police Department officers, quote, shall not take law enforcement action on the basis of actual or perceived immigration status, including the initiation of stops or other field contacts. And let me read the salient part of that again. Police officers shall not take law enforcement action on the basis of actual immigration status. And on February 28, 2016, New Orleans Police Department issued a written policy entitled Immigration Status, which, number one, prohibits officers from inquiring about an individual's immigration status. Number two, prohibits officers from assisting or supporting ICE's immigration enforcement. And number three, mandates any ICE request for support or assistance be declined. The New Orleans Police Department policy was not only vetted, but, quote, enthusiastically approved and supported by DOJ's Civil Rights Division. It was also reviewed and approved by DHS. The Department of Justice and Department of Homeland Security enthusiastically approve and support the failure of law enforcement to take note of federal immigration laws. In addition to being mind-numbingly antithetical to the faithful execution of the law, which is among the primary responsibilities of the executive branch, this New Orleans policy statement appears to violate Section 8 U.S.C. Code 1373, which provides no person or agency may prohibit or restrict federal, state, or local agency from sending, requesting, receiving, or exchanging information with ICE regarding unlawfully present aliens. On May 28th of this year, Chairman Goodlatte sent a letter to now Attorney General Lynch demanding that she explain DOJ's role in initiating litigation against the City of New Orleans and the resulting consent decree, and provide the legal justification for approving the sanctuary policies enacted by the police department. On May 31st of this year, DOJ Inspector General Michael Horowitz issued a memo to the Assistant Attorney General for Justice Programs in response to a request to investigate allegations that over 140 state and local jurisdictions received DOJ grant funds and they may be in violation of federal law. Specifically, the Inspector General was requested to investigate allegations the 140 jurisdictions who are recipients of funding from the Department of Justice are in violation of Title 8 U.S.C. Section 1373. For those of you who may be struck by the duplicity of the chief federal law enforcement entity providing grant money to state and municipalities who specifically fail to assist in the enforcement of federal law, you are not alone. The Inspector General found the laws and policies in several jurisdictions go beyond regulating responses to ICE detainers and also address in some way the sharing of information with federal immigration authorities. After specifically reviewing the language of the New Orleans Police Department policy, and the Inspector General found, and I quote, "In our view, subsection A of the policy would not serve as a, quote, savings clause in addressing section 1373. Thus, unless the understanding of the police department's employees is that they are not prohibited or restricted from sharing immigration status information with ICE, the policy would be inconsistent with section 1373. On July 7th, DOJ's Office of Justice Programs determined section 1373 is, quote, an applicable federal law for purposes of determining statutory eligibility for relevant DOJ grant funding. Yet despite the requirement of section 1373, DOJ awarded the Police Department New Orleans approximately $2 million in grants for fiscal year 2015. That very same day, July 7th, DOJ responded to Chairman Goodlatte's letter. They outlined the policy, but they failed to explain how the New Orleans policies are lawful, which was a pretty important part of the letter in the first place. Then last Friday, September 23rd, just a few days after our hearing was announced, we received a letter from the Department of Justice claiming the revised policy the New Orleans Police Department had issued did comply with 1373. However, this revised policy makes no mention of Part B of Section 1373. And in addition, DOJ has not provided this committee with any indication of how officers will be trained to implement this revised policy or how seemingly minor changes to the text will ensure New Orleans will not be operating as a sanctuary city, which leads us to why we are here today. Not only does this place ICE agents and officers at greater risk when they're forced to arrest criminal aliens who are no longer in a secure jail facility, but instead in public places where they can more readily escape or assess a weapon, but it also prevents officers from accomplishing their ultimate goal, which is public safety. We already know there are cities more interested in providing a sanctuary for criminals than a safe haven for our very own citizens. We know there are cities who clamor for the federal government to assert itself into matters that are not inherently federal in nature, but refuse to assist federal law enforcement in matters that actually are inherently federal. And to put this in terms that almost anyone can understand, state and local law enforcement can be trusted to provide security for members of Congress, both here and in our home districts. They can be entrusted to enforce murder laws, child sex laws, kidnapping laws. They can participate in federal task forces on terrorism and narcotics trafficking. But God forbid they lift a finger to assist in the enforcement of federal immigration laws. But for the Department of Justice to go as far as seek a consent decree to actually inhibit the ability of the federal government to enforce federal law is stunning, even for a Department of Justice that has unfortunately become increasingly politicized. The consent decree can be interpreted to require New Orleans adopt policies that require its officers to actually violate federal law. Let me repeat that one more time. This administration's Department of Justice is actually requiring New Orleans police officers to break the law in an effort to further their political agenda. We have had multiple hearings on those that have been victimized by sanctuary cities. We've heard from their families. We're well aware of the tragic consequences. This is not a theoretical conversation in some law school conference room. This is real life with real victims and real grieving family members. Illegal immigration is not a victimless crime. Once you weaken the law, you weaken it forever. And once you put politics above the blind application of the law, it is done forever. And once you decide state and local law enforcement are good enough to protect us when we're back home in our districts, but not good enough to be trusted to assist in the execution of the law, good luck reversing that. With With that, I would recognize the gentlelady from California.
Thank you. Thank you, Mr. Chairman. Today we're again devoting time to what the majority calls sanctuary cities. It's ironic that my Republican colleagues today argue against local policies in favor of a top-down mandate from Washington. It's a question why the majority believes that it knows better than several hundred state and local police departments across the country that have embraced community trust policing policies precisely because they believe that approach makes us all safer. And for the Republicans to question the need for good community policing approaches at this moment, when reports of tragic police shootings dominate the news, seems nonsensical. The fact is, we could have addressed the Republican concerns with sanctuary cities and many other immigration matters if we had devoted time spent on polemics and diversions instead of to fixing our broken immigration system through comprehensive reform. When it comes to so-called sanctuary cities, this is what Richard Beale, the police chief of Dayton, Ohio, not a place many think of as a sanctuary city, said over a year ago when he testified before the Judiciary Committee, quote, "These policies allow us to focus our limited resources on our primary mission, crime solving and community safety. They also send the message that victims of violent crime, human trafficking, and other crimes should never be afraid to reach out for help due to fear of the immigration consequences." I note that in the Department of Justice report investigating the New Orleans Police Department dated March 16th, 2011, it said, quote, "Minority groups nearly uniformly said that the police rarely reach out to them for any purpose. One member of a Vietnamese community organization reported that, quote, "A lot of young Vietnamese people who get shot in this community, we know who shot them, but the New Orleans police won't do anything. They don't talk to us. They don't build community relationships." I agree with Chief Beale, and I know from my experience as a county supervisor and member of Congress that law enforcement and local officials can work cooperatively with community groups and the federal government to come to a consensus position that preserves community policing and prioritizes serious criminals for immigration enforcement and removal. I also agree with Secretary Johnson's prior statements to this committee that imposing federal mandates on local law enforcement by withholding funds would be a huge setback in efforts to improve the relationship between DHS, state, and local law enforcement and communities around the country. With respect to New Orleans, the context, like most things in the Big Easy, is a little bit different. Upon taking office, Mayor Landrieu requested the Department of Justice Civil Rights Division engage in a review of the police department. He recognized that a history of civil rights violations by the New Orleans Police Department had undermined trust with the community and reform was necessary. Of course, the vast majority of New Orleans Police Department officers honestly and conscientiously performed and continue to perform their duties. But I hope that my Republican colleagues are not here to defend the actions of a few that caused such great harm over the years in New Orleans. The history of abuse by the department has been well documented. The facts are incontrovertible. Under Mayor Landrieu and Superintendent of Police Michael Harrison, with the support of the Department of Justice and working with the local community, New Orleans entered into a consent decree and has adopted a bias-free policing policy. The policy ensures that immigrants can report crimes and serve as witnesses without retribution. It also makes clear that information regarding the citizenship and immigration status will be shared with federal immigration authorities when required by federal or state law. Out of an abundance of caution, New Orleans has been working with the Justice Department to revise this language to guarantee its compliance with applicable federal laws. And we now have this revised policy in place. These policies, while not self-identified as sanctuary city policies, are examples of smart, effective community policing tailored by and for the communities in New Orleans. Many are hopeful that this hard work, done collaboratively with the department and community groups, sets New Orleans on a path to safer streets and better police relations with citizens of all backgrounds. But here comes the Republican Congress to the rescue. They're questioning the legality of a policy that has already been revised to ensure that it is in compliance with federal law. Members who have had nothing to do with New Orleans are here to tell the local police and civil leaders how to do their job, even though the New Orleans Police Department says the Republican approach will undermine public safety and make their jobs harder. They're pursuing a line of argument that jeopardizes critical funding which supports public safety, community policing, and crime victims services. With all due respect, I say to my colleagues on the other side of the aisle, let's let local law enforcement and the elected officials in city government do their job, and we should focus on ours. In this Congress, we've gone to the floor to vote on bills to deport dreamers, to deport the parents of U.S. citizens, to deport vulnerable children fleeing persecution and sex trafficking, and to halt refugee processing amidst a civil war in Syria that has displaced millions. Thankfully, these proposals have ultimately gone nowhere, but we had the votes to pass comprehensive immigration reform in the last Congress. The bipartisan bill passed in 2013 would not only have grown our economy, helped to shrink our budget deficit, it would have made our communities safer. Bringing people out of the shadows and putting them on a path to citizenship would have further enhanced public safety. If the Republican leadership had given comprehensive immigration reform the same opportunity for a vote that all of these other measures have received, it would be the law today. So let's do the people's business, work to pass immigration reform. And I thank the chairman. I yield back the balance of my time.
Gentlelady yields back. The chair will now recognize the gentleman from Virginia, the chairman of the full committee, Mr. Goodlatte.
Well, thank you, Mr. Chairman, and thank you for holding this important hearing. Sanctuary cities refuse to cooperate with U.S. Immigration and Customs Enforcement in its enforcement of federal immigration laws. The proliferation of sanctuary cities has resulted in thousands of criminal aliens being released into our neighborhoods to commit more crimes. Sanctuary cities violate federal law. 2 decades ago, Congress enacted a provision, Title 8, Section 1373, designed specifically to prevent jurisdictions from enacting policies that prohibit their employees from sharing information with ICE about illegally present or criminal aliens. There are more than 300 sanctuary jurisdictions in the United States. One of these is the city of New Orleans. In 2010, the current mayor of New Orleans invited the Department of Justice to review the policies of the New Orleans Police Department, apparently in part to transform New Orleans into a sanctuary city. Former Attorney General Eric Holder, former Assistant Attorney General for the Civil Rights Division Thomas Perez, now Secretary of Labor, and the mayor appear to have colluded to have the Department of Justice file a lawsuit against the city and then have DOJ and the city enter into a settlement agreement or consent decree that would forbid the New Orleans Police Department from cooperating with ICE. The resulting consent decree actually required the New Orleans Police Department to develop a plan that prohibited officers from taking any enforcement action based on an individual's immigration status. In February of this year, pursuant to the consent decree, the New Orleans Police Department issued a policy prohibiting officers from inquiring about an individual's immigration status. More troubling, it generally prohibited officers from assisting or supporting ICE's immigration enforcement, and it required officers to decline all ICE requests for support or assistance. Thus, New Orleans could claim that DOJ's heavy hand forced it to become a sanctuary city and endanger its residents when in fact it was a willing participant. The consent decree was a shocking action on the part of the Department of Justice. The chief law enforcement agency of the federal government acted to impede the enforcement of federal law. In addition, the policy appears to be in direct violation of Section 1373. Yet it was excuse me. Yet it was reviewed and approved in advance by the Department of Justice Civil Rights Division. This appears to be another example of the current DOJ's cavalier disregard for the Constitution and the law. Chairman Gowdy and I sent a letter to the Attorney General in May asking that she explain how the New Orleans Police Department policy complies with Section 1373 and requesting that she provide communications with New Orleans concerning the development of the policy. DOJ's response was almost completely non-responsive. The DOJ Inspector General issued a report in May that expressed concern that ambiguous language in some sanctuary policies may cause local officers to comply with such policies in a way that would violate Section 1373. The Inspector General noted that unless the understanding of New Orleans Police Department's employees is that they are not prohibited or restricted from sharing immigration status with ICE, the policy would be inconsistent with Section 1373, end quote. I have asked for the training materials that the New Orleans Police Department gave to its officers to ensure their understanding of Section 1373. I have been provided with nothing. This leads to a troubling possibility that through a lack of training, the New Orleans Police Department has, in practice, violated Section 1373. Finally, just 4 days before this hearing, after this committee's persistent efforts to expose this disturbing matter and demand action, the Department of Justice informed the committee that the New Orleans Police Department had revised its sanctuary policy. Specifically, the NOPD policy now states that it is to be construed in accordance with Section 1373A. On that basis, DOJ has represented to the federal court and this committee that the policy now complies with Section 1373. Unfortunately, this coordinated effort by DOJ and the City of New Orleans to preserve the patina of legality of their consent decree clearly fails. Section 1373B prohibits jurisdictions from restricting their employees from requesting information from ICE, maintaining such information, and exchanging information with other agencies. Nowhere does the revised policy require compliance with this subsection. A NOPD officer that arrests an individual who is believed to be illegally present is most likely going to contact ICE to request information regarding that individual's immigration status. However, the revised NOPD policy expressly prohibits the New Orleans Police Department officers from making inquiries into an individual's immigration status. DOJ and NOPD have provided no evidence that NOPD in practice has complied with Section 1373. They have provided no training materials showing that officers have or will be properly trained regarding compliance with Section 1373. The New Orleans Police Department received over $2 million in law enforcement grants from the Department of Justice in fiscal year 2015. As Attorney General Lynch has essentially admitted to John Culberson, chairman of the House Appropriation Committee's subcommittee with jurisdiction over the Department of Justice, if the New Orleans Police Department is in violation of Section 1373, it would be disqualified from receiving these grants. Yet, the Department of Justice has made no effort to cut off grants to New Orleans. Even aside from the likely violation of federal law, the Department of Justice's actions in this case show that the protection of our constituents and the enforcement of federal law no longer seem to be priorities of the department. In fact, the Department of Justice seems to view them as roadblocks, impeding its chosen policy preferences. I want to thank our witnesses for appearing today, and I look forward to their testimony and to learning more about how this new New Orleans Police Department policy, including why it still prohibits compliance with Section 1373B. Thank you, Mr. Chairman.
Gentleman from Virginia yields back. The chair will now recognize the gentleman from Michigan, the ranking member of the full committee, Mr. Conyers.
Thank you, Chairman Gowdy. And I join in welcoming all of our witnesses. I'd like to preface my remarks regarding today's hearings, which deals with community policing policies, by observing that our nation's conscience continue to be rocked by a series of tragic events involving law enforcement and the loss of too many black lives. In our courtrooms, in our streets, and on television, we confront a never-ending body count. Earlier this summer, my congressional colleagues and I staged an unprecedented sit-in just to try to get a vote on common-sense gun legislation. In this committee, Chairman Goodlatte and I formed a bipartisan policing strategies working group to begin examining how we can best ensure that Congress takes responsibility for the conversation about race and policing in America. I believe this working group is one of the best examples of how we can come together at a time when the nation needs our leadership to reduce the levels of violence in our communities. And just this past week, I joined my Congressional Black Caucus colleagues in protest of yet another series of senseless killings of black men and black children by police in Cleveland, Tulsa, and Charlotte. When you add to this volatile mix the attacks on the police officers in Baton Rouge and Dallas, the nation risks being forced into a battle of whose lives matter most. We mourn the loss of all of these lives and want to see an end to this violence across the United States, including in the iconic American city of New Orleans. To achieve this, first we need to ensure police accountability, prevent violent attacks on law enforcement, and improve the relationship between police officers and the communities that they are sworn to protect and serve. Community trust policies are integral to smart law enforcement for diverse communities, including those with immigration populations like New Orleans and my district in Michigan. Secondly, studies show that crime rates actually decrease after localities adopt community trust policies. Further, these studies find that strong-arm policies, such as secure communities, fail to lower crime rates. Instead, they make communities less safe because residents become more fearful and therefore less likely to report criminal activity or cooperate with investigations. We share the common goal of community safety. To suggest that local leaders and law enforcement officials are purposefully pursuing policies that make their communities less safe is simply false and offensive. Finally, if we're looking for real solutions, we should be undertaking comprehensive immigration reform. Unfortunately, this hearing, which pejoratively refers to New Orleans community trust policy as a sanctuary city policy, is not about comprehensive immigration reform. It's about anti-immigrant politics and fear-mongering. An immigration reform bill, such as the measure that passed the Senate in 2013, or the legislation that had 201 House co-sponsors in the last Congress, would allow law-abiding immigrants to come out of the shadows and get right with the law. And it would enable immigration customs enforcement to focus its resources on deporting the worst elements. The kind of solution would help ensure that the city of New Orleans and all communities, citizens and immigrants alike, as well as the brave men and women serving in law enforcement, are protected from harm. And in closing, I thank the chairman, and I look forward to a meaningful discussion in this hearing from our witnesses. Thank you, Mr. Chairman.
Gentleman from Michigan yields back. We have a very distinguished panel of witnesses, and I will begin by swearing them in. If you would, please rise. Do you swear the testimony you're about to give is true, the whole truth, and nothing but the truth, so help you God? May the record reflect all the witnesses answer in the affirmative. You may sit down. We'll introduce you en banc, and then I'll recognize you individually for your opening statements. First, it's my pleasure to welcome the Honorable Jeff Landry, who's the Attorney General for the state of Louisiana. Attorney General Landry joined the Louisiana National Guard in high school, taking part in Operation Desert Storm, and served as both a police officer and a sheriff's deputy. General Landry ran successfully for Congress in 2010 and served in the 112th Congress. He became Louisiana's Attorney General on January 11, 2016. He has a Bachelor's of Science degree from the University of Southwestern Louisiana, which is now the University of Louisiana at Lafayette, and a law degree from Loyola University New Orleans Law School. Welcome, Attorney General Landry. The Honorable Michael Horowitz is the Inspector General for the Department of Justice. He worked as an Assistant U.S. Attorney for the Southern District of New York before joining DOJ in 1999, where he served as Deputy Assistant Attorney General and Chief of Staff in the Criminal Division of Main Justice from 1999 to 2002. General Horowitz also served as Commissioner of the U.S. Sentencing Commission. He was sworn into his current position on April 16, 2012. He graduated with highest honors from Brandeis University and earned his law degree with high honors from Harvard Law School. Welcome, Inspector General Horowitz. Next, it's my pleasure to introduce Ms. Vanita Gupta. She is the Principal Deputy Assistant Attorney General and the head of the Civil Rights Division at the Department of Justice. Ms. Gupta worked as a civil rights attorney and deputy director of the American Civil Liberties Union. She became head of the Civil Rights Division in 2014. She earned her undergraduate degree with high honors from Yale University and a law degree from the New York University School of Law. Welcome, Madam Attorney General. And Mr. Zach Butterworth is the Director of Federal Affairs for the City of New Orleans, representing Mayor Mitch Landrieu and the New Orleans Police Department, the International Airport, and the Regional Transit Authority and Water Infrastructure System. Mr. Butterworth served as the Legislative Director and Counsel to Senator Mary Landrieu and as Senior Counsel to our friend Congressman Cedric Richmond. Mr. Butterworth graduated from LSU and Loyola University New Orleans College of Law. Welcome to each of you. Attorney General Landry, you're recognized for your 5-minute opening.
Thank you, Mr. Chairman, Madam Ranking Member, for the opportunity to address this committee on one aspect of a public crisis of our time, and that's illegal immigration. As Louisiana's Chief Legal Officer, I'm committed to ensuring the rule of law is followed by everyone. Like each of you, I took an oath to defend the Constitution, and I intend to uphold it. Unfortunately, sanctuary city policies undermine our justice system and our national security. As I'm sure you will agree, government's most important function is for providing and securing the safety of her citizens. Sanctuary policies not only jeopardize the ability to protect our citizens, but they also allow illegals to commit crimes, then roam free in our communities. It has been reported that cities with sanctuary policies have seen an increase in crime. One sanctuary city, Los Angeles, saw all crimes rise in 2015. Violent crimes was up 20%, homicides up 10%, shootings of victims up almost 13%, rapes up almost 9%, robberies up 12%, and aggravated assaults up 27%. What is more, ICE recently revealed that over 1,800 illegals released by sanctuary cities were later rearrested almost 4,300 times, committing almost 7,500 new crimes, including rape and child sex abuse. Sanctuary policies encourage further illegal immigration and waste much-needed public resources as they force the federal government to find and arrest deportable criminals already taken into custody by local law enforcement. This spring, I advocated for legislation in Louisiana that would have increased public safety by incentivizing the government agencies to follow the law. Because of this effort, Lafayette Parish is no longer a sanctuary city parish. As of late Friday, the City of New Orleans has changed its policy, allowing NOPD to now allegedly cooperate with federal authorities. By shining a bright light on this dangerous procedure, this committee has already provided a catalyst for change. Let me be clear, I'm not trying to become the immigration police. Between catching child predators, rooting out public corruption, and fighting federal overreach, I have more than enough to do. But I'm here today to push for a change because the administration has not only decided not to enforce the law, but they also have used their power to coerce local jurisdictions in my state to institute sanctuary city policies. In the great city of New Orleans, the Justice Department entered into a consent decree with the city that mandated that its police officers not make inquiries into an individual's immigration status or assist ICE unless there is a warrant or court order issued. As a former police officer and sheriff's deputy, I find it unconscionable that criminals who are in our country illegally cannot be held until a warrant or a court order is issued. After all, American citizens can be stopped on reasonable suspicion, arrested on probable cause, and may not see a judge for 2 to 3 days. Illegal immigrants should not be given a greater right than we afford our own citizens. After hearing testimony in the State House in Louisiana that the Department of Justice, the U.S. Department of Justice, mandated that the city of New Orleans adopt a sanctuary city policy as part of the consent decree, I wrote a letter to Attorney General Loretta Lynch asking for clarification. The response that this committee and I received was a lengthy non-answer that we have unfortunately come to expect from the administration. However, a recent report by the DOJ's own Inspector General confirmed that sanctuary jurisdictions violate federal law by prohibiting communication with ICE officials. Furthermore, it explicitly declared that local jurisdictions comply with all federal laws in order to receive federal grants. All the while, the administration has been rewarding sanctuary cities with hundreds of millions of dollars of federal tax money. I was criticized by the governor of Louisiana and the mayor for allegedly jeopardizing state funding with the legislation that I supported. The truth is that the U.S. DOJ's mandated policy upon the city is what is jeopardizing their funding. Besides fiscal and legal issues, there are homeland security issues. Due to sanctuary city policies, foreign terrorists, such as members of ICE, have the ability to travel to a sanctuary city, commit a minor offense, and remain protected from being identified. And in the current environment, why would we discourage cooperation between state and local law enforcement? Reducing crime and saving lives are not a partisan issue. In fact, politics never came up when I met with the family of St. John the Baptist Parish Fire Chief Spencer Chauvin's family. Chief Chauvin was killed last month in the greater New Orleans area by an illegal alien with a lengthy criminal background who was in our country. The questions were not Republican or Democrat, conservative or liberal. This grieving family simply asks one thing that this committee, Congress, and administration should absolutely answer. Why do we have to wait for illegals to victimize our citizens in a violent manner before deporting them? And I pose to you an even humbler one. Why cannot state and federal law enforcement work collaboratively to prevent these types of actions? Honorable members, we need sound immigration policy that begins with securing the border and enforcing the immigration laws already on the books. Congress must act to support those of us at the state and local level who have been fighting these reckless sanctuary city policies. I'm proud that our efforts expose the actions of DOJ and the city of New Orleans have resulted in substantive changes with the city's policy. Because of the efforts we made in Louisiana, our state no longer has any jurisdictions prohibiting them from communicating with federal immigration authorities. Today, Louisiana is safer because of these changes. Thank you very much, and I look forward to answering any of your questions.
Thank you, Mr. Attorney General. Inspector General Horowitz.
Mr. Chairman, ranking members, members of the committee, thank you for inviting me to testify before you today. Earlier this year, the department advised the Office of Inspector General that it had received information indicating that jurisdictions receiving department grant funds may be in violation of Title VIII, United States Code Section 1373. The department provided the OIG with grant information related to more than 140 state and local jurisdictions and asked our office to review the allegations. We considered the matter as requested and subsequently provided the department with a memorandum advising it of the steps we had taken and summarizing the information we had learned. We did so expeditiously because, in part, the department's grant process was ongoing, and we found that the department had not provided grant recipients with clear guidance as to whether Section 1373 was an applicable federal law with which recipients were expected to comply in order to satisfy relevant grant rules and regulations. Based on the large number of jurisdictions cited by the department and the need for us to review this expeditiously, we judgmentally selected 10 state and local jurisdictions for further review. For each jurisdiction, we researched the local laws and policies that govern their interactions with U.S. Immigration and Customs Enforcement and interviewed ICE officials to gain their perspective on ICE's relationship with the jurisdictions. Based on our research, we found that the laws and policies of several jurisdictions went beyond placing limitations on complying with civil immigration detainer requests and potentially limited the sharing of immigration status information with federal immigration authorities. We also found that the laws and policies of some jurisdictions in our sample group that address the handling of ICE detainer requests might have had a broader practical impact on the level of cooperation with ICE and therefore might be inconsistent with the intent of Section 1373. ICE officials expressed a similar concern to us. With regard to the New Orleans Police Department, we noted that its then existing policy broadly prohibited officers from disclosing a person's citizenship and immigration status information, with an exception where the disclosure was, quote, required by federal or state law, close quote. This savings clause language appeared to be potentially inconsistent with the plain language of Section 1373 because, for example, Section 1373 doesn't, quote, require, close quote, cooperation with ICE, but rather prevents jurisdictions from prohibiting or restricting employees from providing immigration status to ICE upon request. In our memorandum, we advised the department of several steps it could consider taking to the extent its focus was to ensure grant recipient compliance with Section 1373. Among the steps were to provide clear guidance to grant recipients regarding whether they would be expected to comply with Section 1373 in order to satisfy relevant grant rules and regulations, to require grant applicants provide certifications and supporting documentation regarding compliance with Section 1373, and to consult with the department's law enforcement counterparts at ICE and other agencies regarding such issues prior to grant awards. We believe the steps we outlined would provide the department with assurances that a grant applicant was operating in compliance with Section 1373, and also would be helpful should the department later refer alleged violations of Section 1373 by grant recipients to the OIG for our investigation. This concludes my statement, and I will be pleased to answer any questions that the committee may have.
Thank you, Mr. Inspector General. Madam Attorney General.
Thank you. Good morning. Good morning, Chairman Goodlatte, Chairman Gowdy, Ranking Member Zoe Lofgren, and distinguished members of the subcommittee. Thank you for the opportunity to speak before you today about the Justice Department's work to advance public safety and promote effective constitutional and community-oriented policing. Around the country, state and local law enforcement serve as the first line of defense for public safety. They keep our families safe from harm, they fight crime on our streets, and as recent events painfully remind us, they do this demanding, often dangerous work at great sacrifice and great personal risk. So let us make no mistake, the vast majority of men and women who wear the badge serve our communities with professionalism, with integrity, and with distinction. They deserve our deepest respect and our steadfast support. Yet when police departments engage in a pattern or practice of unconstitutional policing, their actions can severely erode community trust and profoundly undermine public safety. In 1994, Congress charged the Justice Department with a responsibility to investigate law enforcement agencies for a pattern or practice of conduct that violates federal law, and when necessary, to develop remedies to eliminate such misconduct. Today, I'll discuss our work with the New Orleans Police Department by explaining the problems we found and the reforms that the city agreed to implement. In May 2010, New Orleans Mayor Mitch Landrieu requested that the Justice Department conduct an independent investigation of NOPD's systems and operations. In a letter, Mayor Landrieu stated that he inherited a police force described by many as one of the worst police departments in the country. Following our fact-driven and comprehensive investigation, we published our findings in a detailed 141-page letter. Among other violations, we found evidence that NOPD was unfairly enforcing the law or failing to enforce the law based on race, ethnicity, national origin, and other protected characteristics. These discriminatory policing practices eroded trust. Crime victims and witnesses, especially in Latino communities, felt afraid to share information with the police. This hurt public safety. In the context of reporting crime, one community member told us, "Out of fear, we stay quiet." I know many law enforcement officials and leaders around the country understand these concerns and recognize the very critical and important link between community trust and public safety. In 2012, New Orleans and the Justice Department entered into a comprehensive negotiated consent decree approved by the federal court in 2013 to resolve our allegations of unlawful police misconduct. The decree requires NOPD to make important changes in policies and practices related to the use of force, stops, searches, and arrests, the prevention of discriminatory policing, and officer training, oversight, and supervision. In February of this year, after seeking input from the New Orleans community, the court-appointed monitor, the federal district court, as well as the U.S. Departments of Justice and Homeland Security, NOPD issued a new policy to help officers provide services effectively and fairly to all people in the city, regardless of their immigration status or the color of their skin. Last week, NOPD updated its policy to clarify that it complies with a specific federal statute, 8 U.S.C. Section 1373, to ensure that officers understand that they can send and receive information regarding an individual's immigration status and to most effectively advance non-discriminatory policing. The policy also states that NOPD officers can take law enforcement action and assist in immigration enforcement when there's a threat to public safety, to execute criminal warrants, and to safely execute a court order. By facilitating a culture of trust and cooperation, the policy will help local and federal law enforcement protect public safety. The hardworking men and women of the New Orleans Police Department continue to do precisely that by fighting crime and partnering with federal law enforcement to identify and prosecute people who have committed violent crimes. We strongly believe that this policy will help restore trust with crime victims and witnesses, enhance the sharing of information, and in so doing, make the entire New Orleans community safer. In New Orleans and in any city the Justice Department works with, real and lasting reform can't happen overnight. And we recognize the vital role of sustained collaboration with the entire community, from police officers to public officials and to community members. And I want to commend officials from the city and the NOPD for their partnership throughout this process. And I view our dialogue today here as an important part of that same process about how police reform can help make the residents and officers of New Orleans safer for generations to come. I look forward to your questions.
Thank you, Madam Attorney General. Mr. Butterworth.
Chairman Gowdy, Chairman Goodlatte, Ranking Member Lofgren, and Conyers. My name is Zach Butterworth. I'm the Executive Counsel and Director of Federal Relations for the City of New Orleans. Thank you for giving me the opportunity to provide testimony before the committee today.
Hold on. Now it is.
Okay. Thank you, Benita.
Sorry about that.
Before I begin, I'd like to thank the panel for their support that Congress has provided to New Orleans since Hurricane Katrina 11 years ago. Our recovery would certainly not be where it is today without that support. I'd also like to thank you for your strong support of the victims of the flooding of Baton Rouge. I've seen the magnitude of that flood, and those people will certainly need your help for years to come. I want to emphasize three main points from my written testimony and then try to give the panel a little bit of context for how we got here today. First, public safety is a top priority in New Orleans. Legal or undocumented, whoever commits a crime in New Orleans will be arrested. Our record shows that every day, the New Orleans Police Department takes violent criminals off the streets. In 2012, Mayor Landrieu formed the Multi-Agency Gang Unit. That unit alone has arrested 100 of the most violent criminals in New Orleans. Murder is down in New Orleans, 18% from 2011. At the same time, Murder was up 4% nationwide. Violent crime is down in New Orleans, 60%, dating back to its highs in 1994. My second point is that New Orleans policy does not make us a sanctuary city. We are trying to follow federal law. We've been trying to follow federal law from day one. It should go without saying that any police department, any policy a police department adopts follows state, local, and federal law. So the review process here. The NOPD, every policy is reviewed by the Department of Justice, a federal monitor who's appointed by a federal judge, and the NOPD. In drafting our policy, we asked the experts. Officials from ICE were brought in and reviewed best practices from around the country. For instance, the Major City Chiefs Association, which New Orleans is a member, represents 70 million Americans. They support policies that foster trust, cooperation between police officers and immigrant communities that we all serve. And my third point is that NOPD's policy on immigration status will make the city safer. It frees up our officers to focus on violent crime. It also allows anyone to report a crime or to be a witness or a victim to report a crime. The policy is already bearing fruit. On the ground, our commanders are seeing better cooperation with immigrant communities. Quickly going back to 2010, we did invite the Justice Department in. Their comprehensive investigation showed that we had problems in the way that we treated the immigrant community. We wanted to fix that. Since 2010, we've launched 11 new recruit classes. We've written 34 of these types of policies. 40 more are being drafted right now. These policies cover canine use, prisoner transport, taser operations, body-worn cameras, to name a few. Now, going back to March 2015, we started drafting this policy with the NOPD, the Federal Monitor, and of course the Justice Department. In September, we brought in ICE. We asked the experts. They were brought in at both the local and the headquarters level. At the time, ICE told us that the policy complied with all federal ICE requirements for law enforcement. Then in December, Judge Susie Morgan, who oversees the consent decree, also brought in ICE. We had the chief counsel from the New Orleans division in her office. No concerns, substantive concerns about the policy were raised at that time. So in February of this year, the Federal Monitor approved the policy. Immediately, there were some concerns about the policy, so Mayor Landrieu wrote to DHS and DOJ, the leadership there, and said, if anyone in any of your agencies, any person has a concern about this policy, please contact us. It wasn't until July that we received a letter back with information about 1373 and general compliance there. So when we received that information, we immediately went to work redrafting the policy with DOJ, and as the chairman noted last week, the Federal Monitor did approve the updated policy that we believe fully complies with federal law, just as we believe the last policy fully complied with federal law. So simply put, the NOPD's policy on immigration status is going to make the city safer, and it follows federal law. As required by the consent decree, we will review our policies continuously, and I'm happy to take any questions. Thank you.
Thank you, Mr. Butterworth. The chair would now recognize the gentleman from Virginia for his 5 minutes of questioning.
Well, thank you, Mr. Chairman. Mr. Butterworth, let me pick right up where you left off. I appreciate the work that you've done on this, but under the revised policy, the New Orleans Police Department officers are prohibited from making inquiries about an individual's immigration status, including to ICE. Yet Section 1373B authorizes officers to make requests to ICE for such information. So doesn't the policy violate federal law, Section 1373B?
Sir, we believe the policy fully complies with 1373. If there's anything about the new policy that's unclear, we'd be happy to go back and take a look.
Why was there specific reference made to 1373A and certain 1373B was left out of the?
I think the focus of the concerns that have been raised have been on 1373A. I think on behalf of the NOPD, we're happy to go back and make sure that there's no misunderstanding about 1373B. I think, as you just heard,
Are you aware of any concerns on the part of the mayor or city officials or the police department chief or others about authorizing officers to make inquiries about an individual's immigration status?
So as you just heard Ms. Gupta testify, this policy allows officers to communicate with ICE. They're going to help ICE in any sort of public safety event. They're going to help ICE execute criminal warrants, and there's no restriction on the communication between an officer and ICE in this policy.
Is there any restriction on a police officer making a request to ICE for information regarding an individual's immigration status?
There's no, so the way the policy is laid out, if an officer interacts with a member of the public, he or she immediately run that person's name against the NCIC database system. If there is a return that there's a criminal warrant on that person, the person's immediately arrested.
And now you noted in your testimony that the New Orleans Police Department takes criminals off the street. If you find that they're not lawfully present in the United States, what happens after they've been through the judicial process in New Orleans?
So thank you for allowing me to clarify that. New Orleans is a very unique political structure. The mayor is elected parish-wide, our counties, to lead the NOPD. Our sheriff is also elected parish-wide, and he leads the sheriff's department. So I don't represent the sheriff's department, and I apologize that I can't speak on behalf of them, but our officers who arrest someone on a criminal warrant deliver the suspect.
Assuming that they are prosecuted and convicted and incarcerated, not all will be, but those who are, after they have served their time, what does the policy of the New Orleans Police Department and courts say about communications with ICE about the fact that someone's about to be released from jail or released from prison who has been convicted of a crime and is not lawfully present in the United States?
So if a person's convicted of a felony in Louisiana, they're likely sent to Angola, which is a state corrections facility, and I would defer to the Attorney General on the operations of the state corrections facility after that.
And what about the New Orleans jails?
Again, the sheriff of New Orleans operates the jail there, and we have no operational control over the sheriff.
Thank you. Well, let me turn to the Attorney General. Welcome. We're glad to have you back with us, Attorney General Landry, and I want to start by asking you if you believe that as Louisiana's chief law enforcement officer, that the New Orleans consent decree violates federal law.
I believe that prior to the substantive changes that they made, it absolutely violated federal law. The question is whether or not in practice the new changes will remedy that situation. You know, what we have in the country is basically two types of sanctuary city policies. It's either a don't ask policy or a don't tell. What the current New Orleans city, what the prior policy was prior to the change was both a don't ask and don't tell. Now the question is whether or not they seem to have remedied the don't tell portion of that policy, but it doesn't seem that they have made any changes in the don't ask portion.
And it's your intention to make sure that everything within your power to assure that that happens will happen so that they're in full compliance with 1373, not just one subsection of it. Absolutely.
We're going to try to take it upon ourselves to go out and let all law enforcement officers around the state know exactly what 1373 states and how they can avoid violating that statute.
Thank you. And just in general, do you believe it's inconsistent for a jurisdiction to adopt a sanctuary policy that violates federal law and at the same time requests federal law enforcement grant money?
I do.
And what message does that send concerning the rule of law?
Well, again, it sends a terrible one. I think that's part of the demise of our criminal justice system and the reason that we have an uptick in crime across the country when we allow people to flagrantly violate any law and then we just turn a blind eye to it. All that does is lead to those people committing additional crimes and thinking it's okay to break the law.
Well, thank you very much. And I heard your testimony that with the correction of this, when hopefully it'll soon be completely corrected, there will be no communities in the state of Louisiana that would be characterized as sanctuary cities.
Thank you, Mr. Chairman.
Well, thank you. I wish other states had the same effort to have such a consistent record. And I yield back to the chairman.
Gentleman from Virginia yields back. The chair will now recognize the gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman. Ms. Gupta, I understand that in 2005, the Civil Rights Division was involved in investigating New Orleans policy abuse and misconduct in the aftermath of Hurricane Katrina. Can you talk briefly about the acts of abuse your division uncovered as a result of that investigation?
So we launched our investigation into the New Orleans Police Department in 2010 and uncovered very pervasive, widespread acts of misconduct related to specifically excessive use of force, stop searches and arrests, discriminatory policing, and the like. And one of the goals that we had when we had come in at the invitation of Mayor Landrieu was to ensure that the New Orleans Police Department would be able to carry out its core function of providing effective policing and constitutional policing to keep all residents of New Orleans safe. And in our 141-page findings report, we detailed, after extensive data interviews, a lot of engagement with NOPD officers and command staff, as well as community members, that these violations had thoroughly undermined the NOPD's ability to solve and prevent crime in New Orleans. And in the years since we've enacted this consent decree, we've been working collaboratively with the city and with the brave men and women of the New Orleans Police Department to address these and to finally give New Orleans police officers the tools that they need to have the trust of all of their residents and to be able to fight violent crime.
Thank you. We're pleased to be joined today by a member of the full Judiciary Committee who's not a member of the subcommittee, and that's Mr. Richmond, who also represents New Orleans. And so I would like to yield the remainder of my time to him so that he might ask questions, since this is his territory.
Gentleman from Louisiana is recognized.
Thank you, Mr. Chairman, and thank you to the ranking member for allowing me to ask some questions. Let me just start with a couple of things here. And in the opening testimony of our chairman, he said that he believed that the consent decree between the City of New Orleans and the Department of Justice was done through collusion. And I will just tell you that as an African-American male who grew up in New Orleans, who had to deal with the New Orleans Police Department, the police department went under consent decree because of use of force, failing to investigate it, stop and searches without cause, discrimination against African Americans, failing to investigate sex crimes against females and domestic violence, a paid detail system that invited corruption, failing to sufficiently embrace community policing, and immigration as one of them. So I just would like to clear up for anyone who thinks that, you know, we colluded all of that. It's very convenient for a white male from Virginia to talk about collusion in a consent decree. And Attorney General Landrieu, let me just applaud you for working on sanctuary cities, because you believe it's important. But I would ask, can you help our Chairman Goodlatte, because he has 2 sanctuary cities in Virginia. And if you're going to start cleaning up at home. And while we go down the list, we have 4 in South Carolina, every parish in Colorado. We have Sioux City in the Representative King's district. We have Dallas and Travis in Texas. So if we're going to start talking about sanctuary cities, don't just pick mine that you would like to allege as a sanctuary city. Let's talk about all of them, especially the people who are on the committee. And the other thing that we talked about was the unfortunate death of a fire chief, a very respected and loved fire chief in St. John Parish. And I think that that incident happened, the person fell through the cracks, and that's what we should stop. But that has absolutely nothing to do with New Orleans. The guy didn't live in New Orleans. He was never arrested in New Orleans. He wasn't, the company that he worked for was not in New Orleans. That has absolutely no connection to the city of New Orleans. Now, the company was operated out of St. Tammany Parish with an elected official as a co-owner, which I think is deplorable. And I think that we should be looking at prosecution for the owners of the company. But to just single out New Orleans as some city that decided all of a sudden that we wouldn't enforce the laws, just incorrect. Zach, Mr. Butterworth, let me just ask you a question. When did you all initiate trying to make sure that the city's policy was consistent with federal law?
So we began the drafting of this policy in March of 2015, and we began discussions with ICE in September. Those have continued on both the local and headquarters level, and at no point did anyone at ICE ever say that this policy didn't comply with federal law.
And Ms. Gupta, at what point is it your office's opinion that they did not comply with federal law? If at any time did they not comply with federal law?
The Justice Department believes that the policy, even in February, complied with federal law. The revisions that we just put into effect were made out of an abundance of caution after we received inquiries from officials in Louisiana, as well as we reviewed our Inspector General's memo, and in an abundance of caution to ensure total clarity about the fact that the policy must comply with 1373. We literally lifted the language of the statute, put it into the policy to make it very clear that NOPD officers can share information with ICE regarding an immigration status or citizenship status of an individual. They can assist in operations in response to direct threats to public safety or where there's an independent law enforcement reason for doing so. They can assist in executing a criminal warrant. They can assist in the enforcement of court orders. So the revision was made to ensure total clarity with compliance with federal law.
So, in summary, the old policy and the new policy, it's your opinion, both were consistent with federal law?
Yes.
And Mr. Horowitz, do you have an opinion on that?
We ultimately, Congressman, didn't reach a final determination as to the legality or not of the issue, primarily because of the fact that we needed to get the report back to the department in its request expeditiously. And in order to do that, we'd really need to be on the ground, go to the city, look at some of the issues that have been previously been raised, talk with folks on the ground there, both from the city and from ICE. And we haven't taken those steps, and I'm not in a position to give a legal determination at this point without taking a full effort in that regard.
Thank you, and I'll yield back.
Gentleman from Louisiana yields back. The chair will now recognize the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. Sanctuary city policies have transformed some of our greatest American cities. I'm increasingly frustrated by these policies that are consistently implemented in the name of, quote, unbiased and community-based, quote, close quote, policing, as Deputy Attorney General Gupta has said. The ramifications for public safety and the inability for ICE to complete its mission are severe, and not only affect the cities, but the surrounding communities are impacted as well. While some of the witnesses today, including Deputy Attorney General Gupta, would like to ignore this fact, the simple truth is that immigration enforcement is a critical function of the United States government, and one that must be supported and not undermined in this form. Much of this debate centers around the practical application of 8 U.S.C. 1373 and whether a city that has implemented sanctuary policies can simultaneously comply with this section of law. Mr. Horowitz, based on your findings, what do you believe that 8 U.S.C. 1373 requires of local jurisdictions?
In sections 1373A and 1373B, I'll combine them for purposes of just mentioning this, it essentially prohibits state, local, or federal law from prohibiting or restricting in any way employees of those entities from sending to, requesting from, or receiving from ICE information about the immigration status of an individual.
So what do you make of the fact that Mr. Butterworth keeps saying that it complies, but nothing in their guidance says that they have the ability to request information?
The new policy that we also received on Friday afternoon and have looked at doesn't reference the word requesting, which is in B1 of
So
1373.
it clearly doesn't fully comply. It seems to comply with A, but not with B.
It clearly addresses A. It
Clearly
doesn't
addresses A.
include the word requesting, which is in B. Again, without us understanding more, I'm not going to be in a position to give a legal opinion on whether it
But
complies
it's
or
a simple
doesn't, but
word.
it
You
omits the
have-
word
The
requesting.
misrequest, the word request is not in the policy,
That's correct.
Okay. And you believe that we may need to clarify this section, correct?
I think it's an open question. I got it Friday afternoon as well. I'd have to do follow-up, but the absence of the word requesting, which is in 1373B, is obviously a reasonable question here.
Attorney General Landry, great to have you here. Thank you so much for all the work that you're doing. Do you believe that by implementing these sanctuary policies, New Orleans and in particular NOPD are promoting public safety?
By implementing the policies
Yeah.
of sanctuary, absolutely not. I mean, it's a danger to public safety. And what happens is it actually, you know, when you have, most of these cities are very large cities, so you have very large metropolitan footprint. What happens is it creates a magnet, a draw for illegal aliens as a sanctuary area for them to operate. It also creates an opportunity for, if you were a member of the drug cartel in Mexico, where would you send those people who are plying your illegal trade? You would send them into those cities because the ability for those members to be identified is reduced because of the sanctuary city policies.
Is New Orleans a safer city today than before implementing these sanctuary policies?
Well, it's certainly the substantive changes that they made on Friday is a step in the right direction. I think that going ahead and clarifying it and then actually determining whether or not there will be a collaborative effort to crack down on illegal immigration, especially those that are in custody that NOPD has arrested and identifies them, is yet to be seen.
So as a law enforcement official, as someone who has served at both the federal and state level, what do you believe is the appropriate relationship between local or state law enforcement and federal immigration enforcement?
I believe they have to have extreme collaboration. I believe that, based upon some of the U.S. Supreme Court's holding, that Congress needs to clarify exactly how law enforcement agents may engage in those types of questioning. And then, of course, implementing 1373 is certainly a step in the right direction, making sure that law enforcement agents know that they can ask and they can communicate with ICE in order to get those violent criminals off the street and deportable.
Thank you. I yield back my time.
Gentleman from Idaho yields back. The chair will now recognize the gentleman from Illinois, Mr. Gutierrez.
Thank you. I'd like to note that we're not having a hearing today about gun violence. 500 people shot dead in Chicago, 3,000 this year. We're not having a hearing about police killing unarmed civilians. We're not having a hearing about the need for immigration reform or detention centers. We're not having a hearing about any other really important things. We're having a hearing about a Donald Trump talking point, that one he goes to again and again, the one that says that immigrants are killers, rapists, drug dealers who are here to hurt people, not to build up our country like every other immigrant group that's come before them. Today we're focusing on one of America's great cities, a city with a troubling past when it comes to respecting civil rights and building trust between the police and the community at large. And so I would think that we would want to work on building that trust between the police and the people, and that the efforts taken by people to build that trust shouldn't be undermined. Lastly, I'm just going to say, because it doesn't really matter, this hearing, it really doesn't. It's going to come and go. You guys got somebody pay for your trips to come down here, and this isn't going to have an impact on it. We're not going to change anything. This is just another political hearing. But I just want to say that, we could have actually spoken to a lot of very important issues that people want us to talk about. But it always seems the majority always says we should listen to people that are not in Washington, D.C. We should listen to local elected officials. that's where democracy is blooming. But it seems like every time you guys say anything, they have an objection when they don't like it. So, having said that, I just want to say to my colleague from New Orleans, I would like to yield the remaining 3 minutes of my time to Mr. Richmond to ask questions.
Thank you. Attorney General Landry, you said that New Orleans policy would invite undocumented immigrants because of its status as a sanctuary city. New Orleans' foreign-born population is about 6%. Neighboring Jefferson Parish, which is not a sanctuary city, is about 11%. How do we reconcile that with the notion that New Orleans is becoming a safe haven for undocumented people?
Let me clarify that. If there was a misunderstanding, Congressman Richmond, the metropolitan area becomes, as a whole, invites illegal immigrants into that particular area because, again, they feel the ability to travel freely. Again, when you look at not only the actual city that implements the policies, it affects the surrounding areas. Just last weekend in the Lafayette metropolitan area, we had an elderly man get hit head-on by an illegal immigrant who, again, had been arrested multiple times and yet was not deportable. So here we have another family losing another loved one in an area which had previously had a sanctuary city policy.
And look, we have a great working relationship, and I know you're very tough on crime. Let me ask about the incident that killed our fire chief. The company was owned by a person in Louisiana and a state rep from Arkansas. Under Louisiana law, do you have the ability to indict the owners of the company for hiring an undocumented without a license that was driving when he caused that fatal accident?
In Louisiana, I believe the employment of an illegal is not a criminal offense, it's a civil matter.
Well, if it's done in a very negligent manner and without gross negligence, I think we do have some criminal statutes under which, let me just ask this then. If we can find some criminal statutes under which to charge the owners of the company who ultimately are at fault for hiring a undocumented, would you commit to charging them if the facts fit the statute? And I don't mind looking myself.
Yeah, absolutely. Congressman, you're right. We have a great working relationship, and I certainly respect you. And yes, I intend to uphold the rule of law regardless. I would also mention that the sanctuary city legislation that we put forth in the State House just this year passed the State House with large bipartisan support. I think everyone is recognizing that this is a public safety debacle, and that this is a first step in ensuring that our communities are safe.
Thank you, and I'll yield back.
Gentleman from Louisiana yields back. The chair will now recognize the gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. I thank the witnesses for your testimony here today, and I'd turn first to Attorney General Landry, and I'd like to pose a broader concept here, and then ask you to comment on that, and perhaps we'll go a little deeper. And that is that, as I read federal law and immigration law, and as I understand it after these years on this committee, it envisions in its entirety essentially vacuuming up the illegal people in the United States and all of those whom are encountered by law enforcement. It anticipates their removal from the United States, and it requires that when at least federal law enforcement officers encounter someone who is unlawfully present in America, that they shall place them in removal proceedings. Would you agree so far with my characterization of federal law?
I do. I agree with that.
And then, so when I look at this statute, 1373, and I read through the details of 1373, shouldn't it be clear to anyone who intends to comply with the intent of federal law that they are to help facilitate rather than frustrate the intent of federal law?
I agree. Just placing the type of language that's been put in a consent decree dealing with immigration frustrates the law.
And I happen to have a little quote here from Mr. Richmond in a markup March 18th, 2015, which is about the time of the inception of this situation. He's concerned about the police department, the sheriff's office, who have a federal consent decree, and that they are complying with, this is a quote, they are complying with the federal consent decree. Now it will cause the city of New Orleans to lose valuable federal money in terms of DHS and FEMA funds, close quote. I think it's been known that there's been a clear violation here of at least the intent of the consent decree, or excuse me, the intent of 1373 by the consent decree and the underlying policy, which is a sanctuary city policy by my reading of it. Have you had any discussions or have you examined the legal language of this in such a way that that you're aware of any loopholes that are being exploited in this process? It seems to be a collaboration between DOJ and the City of New Orleans.
Well, again, it's concerning that the Department of Justice would go in and basically insert this type of language in a consent decree that had nothing to do with immigration or illegal immigration policies or enforcement of that by local law enforcement in the city. Again, I think that language frustrates the entire consent decree.
Would Fire Chief Spencer Chauvin be alive today if we'd enforced our immigration laws as intended by this Congress?
That is correct. I absolutely. In fact, you could make an argument that everyone who has been a victim or lost a loved one to someone who has been in this country illegally has lost that loved one simply because we failed to enforce existing law.
Would you disagree with a statement made by Donald Trump several weeks ago that there are thousands of Americans that are grieving today because of the loss of a family member, a loved one, due to the failure to enforce immigration law in the United States?
I do. I agree with that.
And I'd say also reinforce that it's thousands. And we've had a difficulty in getting apples to apples in 2 GAO studies. Thank you, Attorney General Landry. And I turned to our Inspector General Horowitz and just ask you just for clarification as I listen to your testimony and I read through your testimony. It doesn't come real clear to me as to your position on whether you believe that the sanctuary policy of New Orleans violates 1373.
We looked at the policy that pre-existed Friday and found they had a savings clause in their provision, meaning that if that employees could comply if required to do so by federal or state law. Our concern was how was that being interpreted and used, because Section 1373 doesn't require anything. It simply prevents state and local jurisdictions and federal jurisdictions from preventing employees from contacting or responding to ICE.
Does the policy prevent them from gathering or inquiring as to immigration status?
Other parts of the policy did address that.
And that seems to be the loophole that we've identified over some years here that's exploited by the local jurisdictions. As my clock ticks down, I'd like to then ask Ms. Gupta, as you spoke about this, is there any federal law or any statute that you're aware of that prohibits law enforcement from profiling and when they exercise their job?
Congressman, let me just make one thing clear, if I could, that there's nothing in the NOPD policy that prevents officers from requesting.
But my question is about, are you aware of any law or any statute that prohibits profiling in the enforcement of law?
Yes, there are, the Constitution obviously prevents the racial profiling in the exercise.
You mean to
of
say that if there happens to be a white-haired, light-skinned, blue-eyed person that has committed a crime and you're on the hunt for them, you can't say that?
Where there is a direct and articulated reason, reasonable suspicion, probable cause, these are the
Can
standards
you characterize the
us.
appearance of a suspect in the enforcement of the law?
Gentleman's out of time, but you may answer.
Sure. Well, it is against the law to engage in discriminatory policing where
Mr. Chairman, I'd
policing
ask
decisions
unanimous
are made.
consent to press this witness until she answers my question. She's evasive in her responses.
Objection.
Well,
The witness has been asked and she has answered.
She's not answered.
She has answered the
I'd
question.
ask a unanimous consent for an additional minute.
Mr. Chairman,
Well-
she has been asked and she has answered.
If the gentleman from Texas would yield, I will address the matter,
I'll be
but
happy
it's
to yield,
hard for me
sir.
to interrupt you and do so. Does the witness feel like she's answered the question as adequately as she's able to do so?
I do. I'm happy to finish the sentence or to yield.
No, you are welcome to finish the sentence.
Thank you. It is illegal and against the law to engage in discriminatory policing, to take policing decisions solely on the basis of one's race or other kind of protected characteristic, yes.
If the gentleman from Iowa has additional questions, we can entertain a second round.
I think the chairman, and I would just point out that I don't believe I did get an answer to my specific question, but I think it's obvious to the members of the panel, and I would yield back.
Gentleman from Iowa yields back. The chair will now recognize the gentlelady from Texas.
I thank the chairman very much, and I do want to express my appreciation when any witness comes to share with this lawmaking body, because we should be problem solvers. So let me thank all of you. I might say that I would join with the comments of my colleagues that are here on this side of the aisle, and particularly my colleague from New Orleans for his pointed and very responsive questioning. But we should be doing criminal justice reform that I hope that we will do. We should be doing immigration reform, comprehensive immigration reform. And there is a point to the fact that there are cities around the nation that may need, as you said, Mr. Horowitz, the clarification that I think your pointed Inspector General's report has offered us. And I think that's a solution. So let me first of all ask Ms. Gupta, thank you again for your service. I don't know where we'd be if we did not have the Civil Rights Division, and I thank you so very much. Have you made any pronouncement that New Orleans or any city in the state of Louisiana at this time is not eligible for federal grants?
We have not.
You've made no public statement. Let me read very quickly into the record the genesis of the Civil Rights Division coming to New Orleans. This was a request by Mayor Mitch Landrieu, requested the U.S. Department of Justice to conduct an investigation. His quote is that nothing short of complete transformation is necessary and essential to ensure safety for the citizens of New Orleans. I believe that you are interested in the overall security and safety of all citizens or all individuals in New Orleans. That was a request made by the mayor. Is that my understanding?
That's right.
And the representative of the mayor, is that my understanding?
That's correct.
Thank you. I understand that you were looking at the use of excessive force, unconstitutional stops, searches, and arrests, bias policing, including racial and ethnic profiling, a systemic failure to provide effective policing services, and systemic failure to investigate sexual assaults and domestic violence. Do you recall that, Ms. Gupta?
That's right.
You were overall dealing with the overall civil rights of that community. So the Inspector General offered 3 points that would help in Section 373. The clarification, I believe, the requiring grant applicants to provide certification about their interaction with ICE, and then ensuring grant recipients clearly communicate to their personnel about 1373. Do you have any opposition to that?
No.
And would you be in compliance or intend to give some guidance to that section?
Yes, it's the reason why we made the revisions most recently was to clarify very clearly that that the policy complies with 1373, that ICE officer, that NOPD officers can share information regarding the immigration status of an individual with ICE, that there's nothing in NOPD policy that prevents officers from requesting immigration status from ICE as well.
I just want to be very clear that there is no ban right now that you've offered and that you are not trying to block. Let me quickly ask this question. I'd like to yield to my colleague from New Orleans. Can you tell me if the sentiment expressed by a chief manager and the policy of the Major Cities Chiefs Association, in particular people like Tom Manger, that policies like the one in New Orleans will enhance public safety, is that something you've heard from other law enforcement agencies? Ms. Gupta.
Yes, thank you for the question, Congresswoman. We have heard this from a number of leading law enforcement leaders, but also I think very importantly, the reason why this policy was undertaken was to help the NOPD fight violent crime. When we, in the course of conducting our investigation in New Orleans, we heard from any number of victims and witnesses who were afraid or refusing to cooperate with the NOPD, who had critical, vital information about crime, and that it was undermining the NOPD's ability to solve and prevent violent crime in those communities.
Thank you so very much. I'm happy to yield to my distinguished colleague from New Orleans, Mr.
The gentleman from Louisiana is recognized for 36 seconds.
Let me just quickly put the great quote that I made in context. It had nothing to do with immigration that Representative King talked about. That quote was because New Orleans was under a federal consent decree, both the police department and the sheriff's department. It was costing us over $50 million a year, which was preventing us from making the jail or the police department constitutional. But since Representative King brought it up, let me just ask you very quickly, Attorney General Landry, can you please coordinate with the Attorney General from Iowa to help them with their 23 sanctuary counties that they have in Iowa? And maybe you can coordinate, are you willing to coordinate with Representative King to help him with his 23?
I would be glad to put on a workshop in all 49 other states.
Mr. Chairman.
With that, I yield back.
Mr. Chairman, I have a submission I'd ask unanimous consent if I might put into the record following documents: a statement from 11 National Civil and Immigrant Rights Organization, statement from the National Immigration Project of the National Lawyers Guild, statement from the National Immigration Forum, statement from Church World Services, statement from 20 law professors led by Christopher Lash, a statement from 17 New Orleans-based community organizations, and statement from the Law Enforcement Immigration Task Force. I ask unanimous consent to submit these documents into the record.
Without objection.
Thank
Chair
you.
will now
I thank the witnesses. I thank you, Mr. Chairman.
Chair will now recognize the gentleman from Colorado, former United States Attorney, Mr. Buck.
Thank you, Mr. Chairman. Mr. Landry, have you ever prosecuted the case?
Sir,
Have you ever prosecuted a case?
a criminal case?
Yes.
Not until being Attorney General.
Does your office prosecute cases?
We do.
Mr. Horowitz, you ever prosecute a case?
I did.
Ms. Gupta, have you ever prosecuted the case?
My office prosecutes cases, yes.
Okay. And Mr. Landry, who is your client?
The state of Louisiana?
The people of the state of Louisiana?
That's correct, yes, sir.
Mr. Horowitz, when you prosecuted cases, who was your client?
People of the United States.
And Ms. Gupta, when you prosecuted cases, who was your client?
People of the United States.
Okay. In your opening, Ms. Gupta, you say police officers on, this is the top of page 4 in your written submission, police officers cannot solve crimes and therefore cannot help victims prosecute criminals or help federal law enforcement deport violent criminals if victims and witnesses feel afraid to share information. Mr. Landry, why would a victim or witness feel afraid to share information?
Only because they would be afraid of the suspect.
Oh, okay. Well, how about if they are in this country illegally and they share information and they're asked about their status in this country? Would they feel afraid to share information perhaps for that reason? They could be deported or held if they were in the country illegally when they reported a case?
I believe if a person is victimized, they would report it regardless of that. But we've seen, look, as a former law enforcement officer, I've seen many communities, especially when you get into the poorer communities, that they're suspect of law enforcement altogether, regardless of their immigration status.
Okay, Mr. Horowitz, could someone feel afraid to report a crime because they, in fact, are committing a crime themselves?
It's been a while since I prosecuted a case, but you could certainly see that being a concern of the individual.
Okay, well, let's go further because it's been a while since I prosecuted the case also. So let's dig deep into the recess of our memory here. Mr. Horowitz, let me ask you something. Is it allowable part of cross-examination to ask a victim or witness a question that would determine their motive for testifying or reporting a crime?
It is, and obviously depends on the judge's ruling as to the scope of it.
Okay, but your interpretation of the rules of evidence in a broad sense, that would be allowed to question about motive. How about veracity?
That would also be allowed, again, to the extent and scope that the judge allowed it.
Okay, and so if somebody were to report a crime and yet they had committed a crime or they had a motive, for example, a U visa, if they wanted to stay in the country, you understand what U visas are. It allows a prosecutor to apply to immigration authorities to allow someone to stay in this country if they are a victim or witness of a crime. It would be fair to inquire of that person whether they had committed a crime themselves by being in the country illegally in order to get a full picture about the prosecutorial merits of a case, would it not?
Presumably, but again, I think it would be, depending on the facts and circumstances, up to the judge ultimately.
Okay, so, Mr. Landry, let me ask you something. When the Department of Justice, the Civil Rights Division, decides that they are going to protect one group of individuals who are committing crimes in this country and make sure that we are not prosecuting another group of individuals, are they in fact choosing which type of criminal they want prosecuted in Louisiana, in New Orleans?
That's correct. It's exactly. We're choosing between what laws we'll follow and what laws we'll allow to be broken.
And why would someone do that politically? What is the political advantage of doing something like that?
You would have to ask them. I wouldn't engage in that type of activity.
No, you wouldn't, because it's unethical, isn't it?
That's correct.
If you believe that you are, in fact, not enforcing the laws, or if you enter into a consent decree and you are not representing your client, the people of the United States, the people who are being victimized, that would be unethical conduct, would it not?
It would be.
Mr. Horowitz, do you agree with that?
Depending on the facts and circumstances, yes.
Okay. I yield back.
Gentleman from Colorado yields back. The chair will now yield to the gentleman from Texas, former U.S. Attorney Mr. Radcliffe.
Thank you, Mr. Chairman, for holding this hearing. But I have to confess that I'm more than just a little bit embarrassed that the American people have to see a congressional hearing dealing with the absurdity of the subject matter that we're dealing with today. Right now, Mr. Chairman, at schools across America, we're hopefully teaching our kids about the Constitution. And with all due respect to my colleagues across the aisle who keep saying that we're hypocritical for asserting that the federal government has a role here, I hope we're doing a better job of teaching our kids about the Constitution than we apparently did in teaching some of our colleagues, because the very first sentence of the Constitution in the preamble is where kids learn that the primary role of the federal government is to provide for the common defense, and the single most important part of that is ensuring the sovereignty and integrity of our territorial borders. Mr. Chairman, that's the reason that we have a federal government. That's the one thing that the federal government is supposed to do. That's the business the federal government's supposed to be in. It's not supposed to be mandating health care decisions for Americans. It's not supposed to be interfering with teachers and parents in decisions about kids' education. We have a federal government to protect Americans against people from outside our borders who might cause us harm, to protect Americans like Kate Steinle in San Francisco, and Spencer Chauvin and Jermaine Starr in Louisiana, and Peter Hacking and Grayson Hacking and Ellie Bryant in my district in Northeast Texas, all of whom were killed by illegal aliens who violated the sovereignty and integrity of our territorial borders to come to this country. And tragically, these are just 5 of the countless victims killed by illegal aliens every year. So, Mr. Chairman, if that's the primary role of our federal government, if that's why we have a federal government, are we really having a hearing about the fact that instead of enforcing our federal immigration laws, the federal government is doing the exact opposite, and as General Landry testified, is actually coercing cities into not complying with federal immigration laws? And then, to add insult to injury, the American people tuning in to this hearing today see that the very same Department of Justice that is tying the hands of law enforcement in places like New Orleans turns around and rewards so-called sanctuary cities by handing out federal funds, even though the conditions for those federal funds is that the recipients abide by federal law. And did I really hear correctly that 2/3 of all federal money going to law enforcement is going to 10 jurisdictions that refuse to comply with federal immigration laws and that harbor the most violent criminal aliens and refuse to cooperate with the federal government to deport them? That, Mr. Chairman, is as shocking as it is shameful. General Landry, you obviously share my frustration. It's why you wrote to Attorney General Loretta Lynch and asked her whether the Department of Justice at the same time that they were enthusiastically approving and supporting the New Orleans Police Department policy, was actually also requiring the city of New Orleans to adopt that sanctuary city policy as part of the consent decree. Did Attorney General Lynch respond to you?
She finally did respond to me some months later with basically a non-answer.
Well, if it makes you feel any better, at least she responded to you. I've written her a lot of letters, and she hasn't responded to any of mine. But we have Ms. Gupta here. Ms. Gupta, you've heard from Mr. Landry, and I've heard the exchange between you and Mr. Butterworth and Mr. Richmond about really trying to clear up the record here with respect to the fact that this policy is and always was in compliance with federal law, but as has been pointed out, the record really underscores that it hasn't been, and that's why Congressman Richmond last year in the markup sought to remove that provision to prohibit sanctuary cities from receiving federal law enforcement grants because of his stated belief that New Orleans would be barred from receiving grants because of immigration provisions in the consent decree. Ms. Gupta, given that there are legitimate concerns in the New Orleans policy by folks here, did you seek a judicial review of the policy by a district court to determine whether or not it complied with Section 1373?
The district court at both points, both in February and in issuing this revised policy, had reviewed the policies. Yes.
Well, my time's expired, but since the Attorney General doesn't respond to any of my letters, Ms. Gupta, I wonder if you might carry a message to her, and that message would be on behalf of my constituents and millions of Americans, that if she really believes in enforcing the rule of law, then I think she ought to be prosecuting jurisdictions that violate federal immigration policy instead of writing them checks. And with that, I yield back, Mr.
Mr.
Gentleman
Chairman,
from Texas yields back. The chair will now recognize himself. Mr. Butterworth, what's the penalty for crossing a border unlawfully?
I would defer to the Department of Justice on any.
Well,
federal
let's try it this way. Who has exclusive jurisdiction over immigration cases?
Again, it's outside of my lane, but I would say it's CBP or ICE.
So it'd be federal. It's exclusively federal.
Yes, sir.
Both, and they're really, unless you can think of something I can't think of, it's either crossing a border unlawfully or overstaying a visa would be about the only ways you could get in the country unlawfully. Only two ways I can think of. You either cross one of our territorial boundaries or you're invited in and you overstay your visa. And those are both exclusively federal. But I think you'll agree with me that almost all of our interactions in life are with state and local law enforcement. It's not an FBI agent who stops us for speeding. It's not an ATF agent who is working the bar scene. So if most of our citizen police encounters are state and local, and yet immigration is exclusively federal, how are the federal officers supposed to know about folks who are not here lawfully?
Sir, the Department of Homeland Security has the PEP program, which I am not at liberty to speak on. But I would say if Congress passed a law that commandeered every local police officer and wanted to pay for that, then I think we would welcome it.
When you say, well, commandeer is such a pejorative word, how about we just say cooperate? I mean, you don't commandeer people for your terrorism task forces, do you? You don't commandeer people for your narcotics task forces, do you? It's called cooperation. And yet you have a policy that says that New Orleans Police Department members shall not make inquiries into an individual's immigration status. What do you mean by inquiries?
Sir, if there's a criminal in New Orleans and an officer interacts with that person and there's a criminal warrant, that person
See,
will be
I don't know what you mean by criminal. You mean if the person has, if there's probable cause to believe that an offense was committed, or if there's already an outstanding warrant?
If there's a state, federal, or local warrant or probable cause that an officer observes conduct that's criminal, they will arrest the person.
All right, and then they can inquire as to the person's status.
Our officers under this policy do not inquire about a person's immigration status.
They can or cannot?
Under this policy, they do not inquire about a person's immigration status.
Why not?
Because we believe that, one, this follows federal law, and two,
How are the federal law enforcement officers supposed to know who is here unlawfully if your officers don't inquire? They're not the ones that are interacting with them. They're not enforcing traffic laws. They don't respond to domestic violence calls. The FBI doesn't have jurisdiction over that. That would be your state and local officers. So how is that supposed to happen?
sir, I think your concerns are with the broader system and not with this policy. In New Orleans, we arrest every criminal that we interact with. We bring them to the jail.
I love the way you phrase that. You arrest every criminal you interact with. They're only a criminal after they've had a jury trial, Mr. Butterworth. They're a suspect up until that point.
Correct.
Mr. Horowitz, if their original policy was okay, why did they revise it?
I don't know the answer to that question, Mr. Chairman. You'd have to ask the Civil Rights Division.
Well, you're a good lawyer, Mr. Horowitz. If the original contract was fine, you usually don't draft another one unless you just love paying lawyers. I mean, if your original indictment was okay, did you have a superseding indictment?
Generally not.
No, you don't. So if the original policy is fine, why did we get this brand new policy?
Well, obviously, our memorandum outlining the concerns we had about the provision that then existed may well have triggered the revisions.
I hate to be cynical, but I think you're right. Ms. Gupta, you said you were a prosecutor. There was a question I got way back in time that I never really had a good answer for. Whenever a family member who had lost a loved one to an act of violence to someone who was out on bond would ask me, why was that person out of jail? I never really had a good answer. I mean, you can cite the Constitution that you're really entitled to bond absent some circumstances, but that's kind of a hollow explanation. So what would the explanation be to those who have lost loved ones to violent crime for people who are here unlawfully and the federal government knows it?
There is, for somebody who's been accused of a violent crime, the NOPD is absolutely entitled and in its authority to prosecute to the law to the fullest. And there's nothing in this policy.
You're either missing my point inadvertently or you're missing my point intentionally. I realize you prosecute people after the homicide. I'm trying to figure out how to prevent the homicide. What is the explanation for why the person wasn't dealt with before the murder?
Well, let me just, again, make clear that the reason we undertook the policy was to ensure that NOPD could fight violent crime, could get the kind of critical information from victims and witnesses who need to share critical crime information with the NOPD in order to solve and prevent violent crime in that
Ms.
jurisdiction.
Gupta, you and I both know that we rely on all sorts of witnesses, some of whom, frankly, expose themselves to criminal liability in the process of cooperating. So the notion that you have to give amnesty to people before they will cooperate with law enforcement has not been my experience. But Attorney General Landry, I'm out of time. You asked the question, how do you answer it when family members ask you, why was this person not dealt with before they committed the act of violence? I never really had a good answer to that one.
Unfortunately, I've had to answer that question in Louisiana here lately. And the best way I answer them is that our system in this country is broken.
With that, I would thank all the witnesses.
Chairman, can I ask unanimous consent for 1 minute, please?
Well, if the gentleman from Texas does it, then I'm sure the gentleman from Texas and the gentleman from Colorado are going to want to do it too.
Let me be very brief, Mr. Chairman.
Okay, you can have a minute.
Thank you so very much. First of all, I want to make it very clear that I don't think there's one member here does not feel the deep pain for the families who lost loved ones, particularly those who died in the terrible crash, trying to help others during the Baton Rouge disaster and flooding. I'm from Texas, and I feel for my brothers and sisters in Louisiana, and I was there for them in Katrina, so my deepest sympathy. I do want to make sure, however, General Landry, you're not asking for New Orleans to be prevented from getting federal funds, is that correct? You're not asking us to block New Orleans from getting federal funds?
I'm asking New Orleans to follow federal law, like I would ask
Right,
all of the
but
cities
you're not
in New
asking,
Orleans.
I understand, but you're not asking for there to be a declaration for New Orleans not to receive federal funds from the Department of Justice.
No, I've been asking for the state to withhold funds from New Orleans for violating federal law.
Okay, but let me ask Ms. Gupta, is New Orleans violating federal law?
No, New Orleans, under this policy, the policy does not violate federal law, and right now we're working with the city of New Orleans to ensure constitutional policing.
That they are communicating with ICE and you're not blocking that? Because that's what I want to make sure is happening.
That's right. The policy makes clear that NOPD can communicate with ICE and request information from ICE about a person's immigration status and citizenship.
And deal with criminals on the
Gentlelady's
street.
time has expired.
Thank you so very much for your service, all of you. Thank you.
That I would thank all four of our witnesses. Members are advised they will have 5 legislative days to submit additional materials to the record. With that, thank you again to the 4 witnesses, and we are adjourned.